Hello guys, and welcome to another episode of my lecture. On today's episode, we are going to be talking about liability X against A, which is a name that I formulated for a very complex rule so that you can understand it better. In my last class, I spoke about admissions made by a person expressly referred to by a party to a suit. And in this class, we'll be talking about liability X against A admissions. Now, Section 22 of the Evidence Act permits the admissibility of evidence made by persons whose position or liability must be proved as against any party to the suit. According to Aguda, the position doesn't err on the side of clarity. The reason Aguda had to state that is because a lot of people said that that provision was not clear. Now, Section 22 tells us that statements made by persons whose position or liability is necessary to prove as against any party to the suits are admissions if such admissions would be relevant as against such party in relation to their position or liability in a suit brought by or against them, and if they are made while the person making them occupies such position or is subject to such liability. You can see now that that's technical. Now I made a little illustration to be able to comprehend where it is necessary to prove the position or liability of X as against A in a suit between A and B. Any statement made by X may amount to an admission if such statement would be relevant against X had a suit be brought against him, and if he had made the admission at the time he occupied such position or was subject to such liability. Now, don't get it confused. This is it. There is a suit here. We have A, we have B. Now, A is the manager or the CEO of a company. Do you understand that? Now, B is bringing an action against A for not properly instructing their staffs as to how to do certain things, which resulted to one of the staff's deaths. Do you understand? Now, the wife of the staff, B, is bringing an action against A, and that action is on negligence. Do you understand that? If you have gone through the law of torts, what are the three elements to be proven here? Number one, a duty of care. Number two, a breach of duty. And number three, damages. Number one, duty of care. Is obvious that employers have a duty of care to their employees. We don't need to prove that too much in court. Damages. Is obvious that somebody has died. However, when it comes to the breach of duty, it now becomes very important to prove. But if we can have X, one of the employees, although one of the ogas also in the company, who can admit that he was in breach to a particular extent, which can then vicariously rub off on A, any admission made by X would be admissible as against A. Do you understand that? That's why I called it liability X against A, because X is admitting that there are certain things that he has done wrong, and such admission can be adduced against A in a proceeding for damages or whatever it is. Where that is the case, any admission of liability by X would be admissible, X being one of the employees in the firm, although an oga, but who can say that yes, there is liability on the part of this firm, and I myself, I am coming here to tell you that to a particular extent I've done certain things that are not good, and this and this and this are the things that I've done. So therefore, X has come to tell us that yes, there are certain things that he has done. Therefore, he's taking responsibility. Liability should be on him. B, he's then bringing X to admit those liability as against A in order to prove a very important factor. Let us say the case against A is vicarious liability. A then is supposed to be vicariously liable as to what X has done, and also negligence as against A, because if A was the proper oga who had the time of his employees, he should have known that certain things were wrong, and because of the negligence of A, he should be held liable. because of also the act of X, A should be held vicariously liable. Now, X has now come to testify. Whatever admission X makes would be admissible against A. Do you understand that? But note that this rule has two things. Number one, X must have admitted liability. That's why I said liability X against A. X must have admitted liability. That is very, very important. And number two, when you look at the latter part of section 22, it says, or liability in a suit brought by or against him, and if they made whilst the person making them occupy such position or subject to such liability. So which means if he said it while he was occupying the position, then that admission is admissible against A. So let us say that the news of the whole thing happened and then he felt sorry. You know the way you act when somebody died and you are like, it's my fault, oh, I shouldn't have this, I shouldn't have that and all that, and somebody was there recording you while you were saying I shouldn't have, which means you were saying that, oh, I did it, oh, what even happened to me yesterday night, why would I have done such a thing which has resulted to somebody else's death. Now in a proceeding, can they admit that I shouldn't have, that X was saying? You understand what I'm saying? As at the time he was holding the position, it was after the whole thing they now sacked him, but he had already admitted at that time that he shouldn't have, and someone brought the record into court that, my lord, come and see you, X admitted that he shouldn't have. Therefore it proves that A is liable because A has been negligent. It also proves that A should be liable vicariously in this case. Do you see that? So when you are talking about liability X against A, we are saying that there is a person here who has admitted wrongdoing, and his admission can be used against A. They can connect a nexus between X and A in a proceeding. It might be a little bit complicated and clumsy, but like Aguda has stated, he said that it doesn't err in the side of clarity, which means that it is actually straightforward if you understand the principle, the underlying principle regarding that rule. And with that, I will see you in my next class, where I'll be rounding up on our class on admissions. In my next class, I'll be discussing about other rules in relation to admission, and there we end our class on admissions and we move on to presumption of fact and presumption of law. I will see you in my next class.